in marriage. And in the very same paragraph says, but of course, the state can regulate entry into marriage so that those involved in incestuous relationships, bigamous relationships, homosexual relationships can obviously be excluded. This has nothing to do with the fundamental due process right to marry. A statement that before he died, apparently, he regretted having made, but, kind of there it is. And then this other case, Turner, which is about whether people incarcerated in federal prisons have a right to marry. And here you get the court agreeing that there is a right to marry, that the prison agents can't bar, can't completely prohibit. And the discussion of what marriage means in Turner does give hope to those who would notch up the meaning of marriage in the constitutional sense to going way beyond opposite-sex couples. But the hope is also thin hope, arguably, because Justice O'Connor, in striking down this prison regulation, says that the right to marry is a right to enjoy the emotional aspects of a loving and mutually committed relationship. It's a right to participate in the spiritual aspects of this relationship. It's a right to signal to the outside world a commitment and a desire to remain together, potentially permanently. And her little rhetorical flourishes become notable in the context of the arguments about same-sex couples because they don't mention procreation, and because, in fact, while in prison, even if married, supposedly procreation is not to occur. It's going to be gratification delayed, if not completely denied. But as I'm saying or suggesting, I would like, as would a lot of others, to see in snippets of the rhetoric or dicta from Loving and Zablocki and Turner a basis for the argument, which, by the way, is accepted completely by Judge Walker in the district court opinion in Proposition 8. The argument that the U.S. Supreme Court has recognized a fundamental right to marry under the Due Process Clause of the 14th Amendment that is, according to Walker, broad enough to encompass the aspirations of same-sex couples. It's a very clear assertion by Walker, but it is not an assertion that is going to be so easily accepted as this case works its way up through the federal judiciary, if it ever works its way up. But before we even get to any question of protection of intimate relationships in the form of marriage, or even civil unions or domestic partnerships, we do have to go constitutionally through a very interesting episode having to do with whether sexual intimacy between two men or two women is or is not criminal or can be subject to criminal penalty. And in the heyday of developments at the federal court level, Supreme Court level, of these notions of substantive due process, liberty interests to avoid procreation, a right of contraception recognized not only within marriage in Griswold and in the privacy and sacred confines of the marital bedroom to be kept safe from state intrusion, but a right quickly extended to all individuals, whether married or not. That is, this right to avoid procreation, and arguably it's corollary or opposite the right to procreate. You also have Roe v. Wade and the what seemed to be the enormous expansion of concepts of personal liberty, personhood, autonomy, protected under the Due Process Clause. And then as the comeuppance in 1986 in Bowers versus Hardwick, where a majority of the Supreme Court upheld an anti-sodomy law from the state of Georgia, and upheld it in a way that suggested just how marginalized, from a constitutional perspective, would be the treatment of gay people. Because the court characterized what was at issue in Bowers not as a right to privacy, not as a right to intimacy, not as a right to be left alone in behind closed doors to consenting adults, but rather as a right to engage in homosexual sodomy. And when stated that way, you sort of knew immediately that the court majority was going to put the next sentence, what a joke. The idea that our Constitution would protect, as a matter of history or tradition, a right to engage in homosexual sodomy. Of course not. The end.
Could you explain Bowers? Is it Hardwick and
Bowers,
Can
yes.
you explain these two cases, Bowers and Hardwick? I just went by pretty fast.
Oh, it's one case, Bowers v. Hardwick,
Okay,
yes.
so you just say
Yeah, and
Georgia case, right?
it comes from the state of Georgia. And it's 1986, and the reason that among the reasons that it's so significant is its anomalous nature in the context of what appeared to be this very steadily broadening set of protections for the notion of individual liberty being tied to personal intimacy. So, Bowers is also the product of intentional litigation on the part of national gay rights organizations. They thought, all people in the 80s thought, people interested in an expansion of liberty, the liberty concept to homosexuals, thought the moment had come, and it just didn't. Not only didn't it come in the mid-'80s, you're also getting the flourishing is really not the word, but the devastation occasioned by the AIDS epidemic. Bowers is decided in 86. It's not until 85 or 86 that newspapers like the New York Times even reports on the number of people afflicted or dying of AIDS. It's not until the mid-'80s that major newspapers even use the word gay or lesbian in the papers. So much of the sort of official advocacy on the part of gay people in this country from 86 until the last 10 years was aimed at overruling Bowers. Because the possibility of moving into the realm of parentage, protected rights of people engaged in potentially criminal behavior to be parents, much less the potential right of having their intimate relationships recognized as not only loving relationships, but as protected by the civil law as marriages, just couldn't begin to articulate that on a broader scale if you had a constitutional decision that upheld the right of the state to declare homosexual intimacy a crime. Now, of course, by the 80s, most states didn't have these laws any longer. But that, in a sense, really didn't matter because you had doctrinal support for the right to marginalize and the right to criminalize. So That's why Lawrence v. Texas becomes, in 2003, really clears the air in many ways for what has happened since, particularly with regard to questions about access to marriage. Lawrence v. Texas very simply and specifically overrules Bowers, but does sort of a lot more than that. But I also have to indicate, as some of you may be aware, on the road to Lawrence, which required enormous amount of sort of litigation energy, not the least of which was marshaling historians, American historians, historians of world events, to challenge one of the key findings, supposed findings in Bowers, that homosexuality and sodomy had long been criminalized and singled out in this country for special attention and punishment. In that the historians put together for Lawrence a series of amicus, friend of the court briefs, that challenged that history. Not the history of the fact of these criminal statutes, but the history of their enforcement, and demonstrated quite convincingly that the era of sort of intense homophobic activity, including efforts to punish through the criminal law system homosexual behavior, was a mid to late 20th century phenomenon, more than it was really present earlier in our history, where the story was just much more complicated. But while all of this is going on, you had this kind of interesting detour in 1996. Two huge things happened, really three. The one of them is 1992, even earlier. First you have Don't Ask, Don't Tell, overwhelmingly supported by Congress, whoopee President Clinton. Then you have in 96, overwhelmingly supported by Congress, whoopee signed by President Clinton, the so-called Defense of Marriage Act. And the Defense of Marriage Act has two parts. One part says that the states, which would normally be obligated to recognize the validity of a marriage entered into in another state, such as a marriage between a same-sex couple, even if they wouldn't allow it in their state, that is the normal rule of sort of mandatory recognition of other states' decisions about the validity of a marriage, the states were off the hook. Basically, they were liberated by Congress from their constitutional full faith and credit obligation. And the other part of the Defense of Marriage Act, from the perspective of federal law, all federal law, suddenly, for the first time ever, we get a federal definition of marriage. Marriage, this institution which has been totally a creature of state law, which has traditionally determined the status. For all federal law purposes, a marriage means the relationship between one man and one woman. Now, at 96, no one was allowing same-sex couples to marry. What was the hysterical reaction all about at the congressional level? Well, in Hawaii, in 1993, was the beginning of what has come to be called the Freedom to Marry movement, with a couple of very intelligent